Chad ever
Threatened
threatened Ashley?
Yeah. Your objection?
Hearsay.
Okay. Overruled.
You can answer, sir.
So you're asking me if he directly threatened her? Not that I know to her person, but definitely in conversation.
All right. And what did he say about that threat?
He needed her gone.
What else was he going to do to her?
He made a comment that when it was all said and done, that he wanted to keep her skull as a trophy.
Did he say that more than once?
I believe he said it on at least 2 separate occasions.
Did he say this in your presence?
Yes, he did.
Ian Friedman, what jumped out at you with that line of questioning, please?
Well, I mean, certainly this was testimony that incriminated Chad, kind of really put this all on Chad, took it away from Erica. You know, but the line of questioning that came by the prosecutor thereafter, you know, did you ever report this and so forth. I see why they were trying to do that. I don't think it quite had the effect that was so intended. But a lot of this case, just like the forensics, you know, falls strictly on Chad at this point. There's a lot missing from intent, from the forensic fingerprint, as we say, to Erica. So that's really, to me, this was just a little bit more of the same.
Right. I wondered if, and we'll see with what Erica's testimony brings and what defense argues in close, but all along, even really before I saw the start of this case, just in our research of it at Court TV, I kept wondering if we're going to see the defense present a theory that Chad Cobb was a batterer and battered Erica as well as Ashley Biggs, the theory that, you know, a tiger never changes its stripes, so to speak, and she was under his power and control. And I wondered if that's where things were going, but we really didn't hear Michael Stefanko testify that his wife ever revealed anything about being battered by Chad Cobb. So I don't know, perhaps I'm wrong there, but that was just a thought. And we have another clip I want to share now, and this is important. This is where Michael Stefanko talked about what Chad told him after the murder of Ashley Biggs. Let's watch.
What did you do then?
After they left?
Yes.
I waited for Chad's phone call.
Did you get a call?
Yes, I did.
About how much later?
Between 5 and 15 minutes after Cindy and Jay left.
Was Chad the caller?
Yes, he was.
What did he say to you? First thing.
The very first thing out of his mouth was, I up.
I up?
I up.
All right. What else did he say, if anything?
After that, he asked me to collect some of his belongings and bring it to him.
What kind of belongings?
Clothes.
Did he ask you about his clothes?
Yes.
Did he ask you to bring anybody else's clothes?
No.
Specifically, did he ask you to bring woman's clothes?
No.
Did he ask you to bring children's clothes?
No.
When he first made his comment, he spoke in the singular, did he not?
Yes, he did.
He didn't speak in the plural, did he?
No, at no point during our conversation.
Oh, some very helpful testimony for the defense right there. Ian Friedman, what did you think of that line of questioning on direct?
I agree with you. I mean, you've got a convicted murderer, according to this testimony, saying that he acted solely by his request for clothes and so forth. So solid evidence. I think this only goes to help the defendant in this case. Absolutely.
You know, with Erica Stefanko and deciding to take the stand, her right, you know, her choosing to go in and testify, how do you think counsel should fashion the questions to sort of fill in some of these gaps in the story? I felt like Chad Cobb's testimony left a lot of gaps, specifically what he did, the fact that he said the two of them didn't plan it together. That was really head-scratching. then hearing the husband and his little bit of involvement in this story, that he got phone calls and was asked to help and bring the belongings, what do you think she should be asked? And, you know, and I know cross will be a whole different story, but just on direct, what are some of the main points you think should be drawn out of Erica Stefanko?
Well, you know, it's difficult. The defense lawyer right now, at least as I'm seeing this trial, really had a very good case of reasonable doubt, at least for the aggravated murder, the murder. I think the jurors are left wondering, you know, did she tamper? Did she help with kind of the aftermath, the cover-up of it? I think that when the defense lawyer gets up there, he's got to really just try to lead her to the truth. And it's going to be difficult because we already heard him say she was not going to testify. Now she is going to testify. So, you know, all the flags are flying for me that ask, how prepared is she? Despite defense counsel's best effort, this case is going all over the place. So I think one could only hope from the defense perspective that, yeah, I'm going to say what happened. She's going to tell the truth, and she's going to explain to that jury in a way that they can accept, because they're suspicious now, that, yeah, maybe she showed up, maybe she helped afterward, but she wasn't involved in this murder. She really didn't know what was going on. I agree with Michael and Ted in what they were saying at the last break. You know, this is going to be a tough one, and it's hard for anyone to predict. You know, the defense lawyer is going to be holding on this one until it's over, no question.
He's definitely got a tough job on this one. You're right, Ian. One last question for you, please, because you practice criminal defense in Ohio, and to the point you just made that really made me think, if this jury were to listen to the evidence and at the end of the day say, you know what, I don't see aggravated murder here committed by her, but perhaps she helped after the fact. Perhaps she was made aware when he called her and said, come pick me up from this cornfield. I just did something horrible. And then she assisted in picking him up or bringing him clean clothes or whatever else, not cooperating or telling the truth with police. What charges might be applicable for that kind of conduct in the state of Ohio?
Sure. So there's a number of charges, some of which have been indicted: tampering with evidence, abuse of corpse, you know, these sorts of things, obstruction of justice, those sorts of counts that are there. I like, Julie, what you were suggesting about kind of that battered spouse defense, potentially to kind of explain why she would even show up. You know, but right now, I think what defense counsel had, and I know they still want to really hold on to it, is just the reasonable doubt. And let me really kind of talk about one thing here that I think is important. As defense counsel, I think that it is critical that the jury does not go back into the jury room with the kind of normal mindset about how we settle disputes. What do I think happened? Who do I believe a little bit more? That's dangerous for a defendant. I think that the number one job right now for defense counsel is to remind and really enforce in the minds of that jury that they have to settle disputes in a courtroom differently than they would at home. Say if you had two kids who were saying, you know, he did it or she did it, which one do we believe more? It's not what we do here. And so they have to enforce that, because on the murder, the aggravated murder, that which will keep her behind bars for the rest of her life, you have to look at the complicity. We have no forensic evidence at all. It's nothing to tie her. The investigation's not tying her at all. You have the defendant who's doing life, the co-defendant, Chad Cobb, who's already doing life, has plenty of axe to grind, but certainly did not do a good job from the stand. But if I'm defense counsel, I'm going to say to that jury, ladies and gentlemen, look at the mere definition of complicity. Did she, and here's really where it is, Julie, this is where I think it all comes down. Did Erica solicit or procure another to commit the offense? And I want to really harp on the one word, offense. Did she aid and abet in committing the offense? Did she conspire to commit the offense? And did she cause an innocent person to commit the offense? And the million-dollar question is, what was the offense? What did they prove here? What was the offense? So I think they're really left, if defense counsel keeps their brain shifted in a way that they are to resolve a dispute in a courtroom, left to, going back to your original question, tampering, abuse, obstruction. That's where this should land. But now, as you know, as a prosecutor, we never know what happens in a courtroom. And as we sit moments now away from the defendant testifying, nobody knows what's going to happen in this case at this point. No one.
So true. Oh, Ian Friedman, loved that legal explainer you just gave us. Always great to have you on the program. Thank you so very much. What we're going to do now is step aside and take a break because the jury is set to be back at any moment to hear Erica Stefanko's testimony in the pizza delivery murder trial. This is Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant, and we are so glad you were with us on this Friday as we continue breaking news coverage in the pizza delivery murder trial. Defendant Erica Stefanko has decided to take the stand and testify in her own defense. That is her right to do so. And as we wait for court to resume and for that to happen, let's take a look back together now at that bombshell moment now.
Ms. Stefanko, you've heard just all of the discussions that I've had with Attorney O'Brien on the record, correct?
Yes, ma'am.
Okay. And you heard Attorney O'Brien indicate that for a period of time you made statements that you did not want to testify. Is that correct?
That's true, ma'am.
Okay. And now you've recently told your lawyer that you, in fact, want to testify on your own behalf. Is that correct?
That's correct.
Okay. You understand that you have a right to not testify, and the fact that you don't testify cannot be used against you. You understand all of that?
I do.
The state of Ohio would not be allowed to comment on the fact that you did not testify in their closing arguments or even make any mention of that to the jurors. Do you understand that?
Yes, I do.
You understand that, and Attorney O'Brien has explained that he went over with you the fact that if you do take the witness stand, you'll be subject to cross-examination by the state of Ohio, and there are a variety of matters that they can cover with you. Do you understand that?
Yes, ma'am.
Okay. Has he answered all of your questions as it relates to your decision to testify or to not testify?
He has.
Do you have any questions for this court at this time?
No, ma'am.
Okay.
Okay. All right. At any moment, Erica Stefanko is set to take the stand and testify in her own defense. And I have a criminal defense attorney expert on the program today to talk with me. Until that moment, joining us from Cleveland, Ohio, Ian Friedman, still with us. Okay, Ian, I want to capitalize on something else here that sometimes I feel like can get lost during trials, and that is that the prosecution maintains the burden in a criminal trial. And I know just as a human being, we love to hear stories. We want to hear the whole story, and so there's always that natural human inclination to want to hear someone's side of a story when really the defense has no burden here. How do you think the defense ought to fashion that explainer, if you will, to the jury when it comes time for close, or even in his questioning of her when she's on the stand today?
Yeah, I think you got to blend it. I think he's got to start with the questioning to her. Why do you want to testify? You know, and she's going to get up there because I want the truth to be told. I want everyone to know exactly what happened. And I think in closing argument, defense counsel's got to get up there and say, look, you know, at the onset of this case, we told you and the judge told you there is absolutely no burden. But yet, Erica wanted to get up. She wanted you to hear all of it. She's got nothing to hide. Because as we know, Julie, when we're selecting a jury during voir dire, even though they say, yeah, I understand, we can't consider they don't testify, they want to hear the other side of it. And so now that the defendant has made up her mind that she's going to testify, you got to go all in. You got to buy all in and say, again, nothing to hide, so why would she just sit quietly by? Hopefully that will appease the jury. Hopefully that will explain to them what they're still suspicious of, which is what did she do in the aftermath here. But he's got to embrace it now, and he's got to go with her.
Sure. And, you know, for some of those things that were brought into this trial, and I'm still scratching my head at how they ended up coming in, but the child abuse allegations, we don't have any child abuse charges on this indictment of her, but we heard Cindy Cobb testify to some bad facts about Erica Stefanko being abusive toward GC, that minor child belonging to Chad Cobb and Ashley Biggs, and we heard from GC herself that Erica Stefanko was abusive and the wicked stepmother. From, I guess, the preparation standpoint, as counsel, you're going to try to prepare your witness as best you can. And for some of this questioning that may come in by the prosecution on cross with respect to those allegations, how would you advise her going into this, and what do you think might be the best way to handle some of that if the state tries to cross on it?
You know, it's tough because, again, it appeared defense counsel did not want the defendant getting up there. The defense lawyer is going to want his client now to keep it really clean, real narrow, what happened then. I think you're right. Probably, if I had to bet, the defendant in this case did not like what she heard. She did not like how she was portrayed, and came that, you know, that final hour decision to testify. Defense counsel, though, has got to kind of keep her away from that. But now that she's going up, it's all open. I mean, the prosecutor can get up there and really get into all aspects of her credibility, get into motivations and so forth. The best the defense lawyer can do is object, say it's irrelevant, it's outside the scope. But this is a great trial judge. Trial judge is going to say, look, this is cross-examination. She decided, the defendant decided to get up there and put it all out there. So, again, this is, as we've said kind of throughout the show today, Julie, everyone's going to be holding on here. Prosecutors have to be real excited about this. I mean, these are good prosecutors. They know where their case is strong and where the shortcomings are, and they know that when a defendant gets up there, you know, more times than not, it's not the best thing for the defense. So, you know, I'm sure they're looking for their opportunity here.
Oh, most definitely. Ian Friedman, great to have your expertise. Thank you so much. It is time to watch Erica Stefanko take the stand. We're going to go into court live. I'm being told the judge is back on the bench. Let's take a listen and watch.